work our way down the table?
Let's do that.
Let's do that.
Sorry. Thank you.
That's all right. So my name is Adam. I'm a commercial practitioner at Blackstone Chambers. I have practiced in other places previously, and I'll tell you more about that after these two gentlemen have introduced themselves.
Good afternoon, my name is Peter. I'm a construction barrister specialising in commercial and construction law at Keating Chambers in London.
My name's Oliver Ingham. I'm a member of the commercial and chancery team at Three Paper Buildings, and I practice in London.
So we've been given a series of questions to which to talk, although we're given liberty to depart from it, and I'm going to follow the structure of those questions because I assume that they're well thought through. The first question is, why did you choose the bar, and why in particular your relevant area of practice? So I started out at the bar, and I then went and worked as an employed barrister within law firms, and ultimately, a number of years ago, came back to the bar. So I'm going to take that question as meaning why the self-employed bar rather than employed practice, either as a barrister or a solicitor. And the reason I take that distinction is that in the modern world, in my experience, if you're operating at the top level, certainly in commercial law, there is a convergence between the practice of a solicitor and the practice of a barrister, even within chambers, partly because of the legal reforms which have allowed solicitors to do more of what we do, partly because of the demands of modern day practice and commerce which require barristers to be more human and more business engaged than they might previously have been, and partly because simply the nature of practice in an employed context requires whoever is within that practice to do whatever the firm requires. And my experience was the team I was in engaged both barristers and solicitors, and we ended up having to do much the same work. The barristers would do a bit more advocacy, but a lot of the solicitors also did advocacy. So that's what I'm going to address. Why did I choose to do it? I enjoy the quasi-academic side of being a barrister, of being a lawyer generally, which is the research, putting things together, thinking of arguments, presenting them, and persuading people of what you think. Even more, I enjoy problem solving. One of the reasons I like being a commercial barrister is that invariably my clients come to me with a problem. They might have preconceived ideas as to how to solve that problem, as may the solicitors, but my job is not just to say, yes, this is your problem and your answer is achieved in this way, but is to propose alternative answers and alternative routes to the answer that might come with benefits, whether it be a shorter lead-in to achieving a result or less cost in achieving the result, or ancillary benefits such as commercial pressure that can be applied to the opposing party, which often is attractive. Probably even more than that, I thrive on the extreme pressure that a commercial advocate is put under frequently, both when you present yourself in con before some very experienced businessmen and solicitors at short notice, or businesswomen and solicitors at very short notice on a pretty complex area that you didn't know much about previously, or in court, where you might be against multiple opponents who are very much more senior than you, or perhaps not more senior, but much more intelligent than you, or better versed in the area of law, and a judge. And it is a tough environment, and I love it. Not everyone does. But that's why I chose to do what I do. And that's ultimately why I went back to the self-employed bar, because there is more opportunity to be in front of a court or a tribunal, such as an arbitral tribunal, than there is when one is employed. I'm interested in commercial law for a whole host of reasons. I'll come back to touch on some of these in due course. But people think commercial law is all about businesses having fights with each other. It's really not. If you're doing good quality commercial work, you see that commerce is a massive driver of geopolitics. So you might be engaged in a shareholder dispute, as I have been, for example. A shareholder in an oil company wants to prevent another oil company with whom it's doing business from engaging with a foreign nation government on a project. Now, all of a sudden, when you get into that, you see actually how the currents of political influence work. It's fascinating. And you also get to learn an awful lot about some pretty interesting parts of the world and how they've developed to the stages that they are now. Countries that we read about every day in the news, projects that we read about every day in the news, and I think that's brilliant. You also get to see a lot about the future in terms of what future technologies and social trends are. Businesses thrive by predicting the next driver of growth. And often one is engaged in the early stage to help them to secure their part in that future. And so you get a glimpse into what some pretty interesting people think is going to happen in the future, which is great in my view. What types of cases do barristers in this area deal with? Commercial law is a very broad church. My practice is focused on pretty core, hardcore commercial work, which is contractual disputes and related things like economic torts. Shareholder and company disputes. I do quite a lot of fraud. There is a lot of fraud out there, unfortunately. A bit of insurance. But I also am often thrown curveballs. As should be apparent from what I've described, for example, the oil companies, there are often public law elements in what I do. I recently have done quite a lot of sports law, which engages its own considerations and is quite interesting, although at root often just really company and commercial law. What do I find appealing about this area of practice? Commercial law, and my experience of it at least, is populated by very, very interesting people. There are thoroughly intelligent, thoroughly driven people across the range of work in the world today. But undoubtedly, at the top end of commerce, you have a self-selecting group and a group that have survived the scrutiny of markets and various employers that are really an elite in terms of intellectual ability and drive. It's not always the case, but you can be pretty sure if you're doing hardcore, top-level commercial work, you'll come across a lot of interesting people. And I find that fascinating. You also get a real insight into what they're doing and the way that they think. When you are engaged on a case, you have to understand your client's business and the problem and the solutions that you might put to them. And that involves often learning in great detail at short notice an awful lot about an area you don't know an awful lot about. Whether it be the mechanics of extracting oil efficiently from a well, or the hydrodynamics of a sewage pump, these are all things I've looked at recently, or simply how the football market works and how clubs operate. Absolutely brilliant. And for someone who has a hunger for knowledge and likes to learn new things, it's brilliant. No 2 days are the same. I used to do a lot of professional negligence. I haven't for a number of years done as much because I found it very repetitive. Now, some people like that, and it isn't always repetitive, and I'm sure my two colleagues to my left will tell me it's not when you get to a decent level of it. But what I find is no cases share the same pattern on the whole. The factual pattern is almost always different, but also the solutions that you fashion. And that's reflected in the pleadings that I read and that I draft. They are much less formulaic than they might be in some other areas of law. And that's not to talk down any other area of law. They all have their own charms. I think equally important is that commercial law, again at a decent level, is typically well funded and hard fought. And that means that you are given the resource to work out the answers to the problems and think about them properly and present them properly. Also, that you are put up against someone else who's had the same resource. And that, if you enjoy the joust of the courtroom and the intellectual challenge of putting together a case and winning it at whatever stage, is fantastic, because you get the opportunity to really explore your own limits and those of your case as well. What are the lifestyle implications of this area of practice? Well, they are significant. There's no getting away from it. To progress your practice, if you are ambitious, you need both a volume of work, which means hours, and loyal solicitors, which means people who are going to give you those hours. And you win both of those things through sweat and toil. Certainly in the early years, I think one has to work incredibly hard, and I certainly have, in the past, for many years on end, put work first. I think it's, in my opinion, others may tell me I'm wrong, others who are more naturally gifted than me perhaps, but I think it's unrealistic to think that you will achieve the top of this field if you are not prepared to work very, very hard and sacrifice things that you want to spend time on outside work. That pressure alleviates as you become more senior, as you have more experience, as you have a greater network of referrer clients, but there's no getting away from it in my view. Also, even when you are more senior, the type of work that I do is often very fast moving, things come in at short notice, you have injunctions, you have urgent deadlines, you have client demands, they might have a board meeting at which they need an advice, or a year end by which they need a result. And that means that you have to jump to those short deadlines, whether or not you might otherwise think the case needed it. And that means that you often have to shift your own life around and the rest of your workload at very short order. And that is stressful. And if you're not enough into what you're doing professionally or what you want to achieve professionally, you might feel that you're making too much of a sacrifice, and that can lead people to an unhappy place. So I think it's something you have to have your eyes open when you go into it. Finally, what are the key skills and personal qualities that you think would make someone succeed in this area or make it very hard to succeed? Well, I think you have to like a challenge, but you also have to like pressure and scrutiny, because fundamentally you are scrutinised all the time, whether it's by your instructing solicitors and your clients reading your advice or listening to you in court, or in the more obvious forum of a courtroom or an arbitration, where you have opponents sitting and listening to everything you say, hoping to seize upon mistakes or ambiguities or weaknesses in your argument, and a judge who might do the same. So you are under scrutiny, you have to enjoy that. I find it exhilarating. I think most people in the profession do, but not everyone does. Also, and this mustn't be underestimated, I think, you have to learn to control the elements of your character that might make you a good barrister. In particular, perfectionism. Barristers, I think, frequently want everything to be perfect and can be quite thin-skinned then about the criticism that they receive. You have to be robust. You have to be able to withstand the scrutiny under which you're put. You have to be able to sit in the courtroom, often for days, whilst the other side makes their submissions and seeks to rubbish you. You have to be able to read pleadings that say that you've pleaded ineptly or that your pleading is incoherent for whatever reason, rightly or wrongly. And you need to be able to bounce back. In fact, you don't need to be able to bounce back. You need to be able to resist it and push back. Perfectionism is a virtue when you're doing our type of work, but you can take it too far. Ultimately, you have to get the work done in the time available. And people can, I think, become closed off to doing what they need to do because they become so obsessed about a minor point of perfectionism. You learn that the commercial realities of practice, you get the job done. Finally, and using up my 10 minutes, be nice. It's sometimes hard, you're knackered, you're under tremendous pressure, people are not giving you what you want, you've asked them 5 times in very clear terms, you think, but fundamentally, clients, whether they are the solicitors or the ultimate clients, or indeed leaders in chambers or outside chambers with whom you want to work, only want to work with you if you are easy to work with. That means you give them what they want, when they want it, with a smile, and you don't give them a hard time. Now, it's something to aspire to, it comes more naturally to some people than others, but it shouldn't be underestimated. We're not brains on sticks, we are a service industry and one has to serve.
Thank you, Adam. My name is Peter, as I mentioned, and I practice at Keating Chambers. Dealing really with the same questions that Adam has dealt with, but from my own perspective. Firstly, why the bar and why my particular area of practice? What attracted me to the bar is the independence that it brings. You are all self-employed, and so you stand and you fall on your own merits. There is only a certain degree to which chambers can help you, and after that it's all you. And nobody achieved greatness purely from their chambers. One has to be a self-starter. Now with that comes a lot of benefits, some of which Adam's mentioned. I enjoy having control of my life. You have no real boss. It's all you. So you can turn up to work a bit late if you have a dental appointment or you've got someone to see or something else is going on in your life. You can dress how you like when you're in chambers, obviously not with clients, but it gives you a certain degree of freedom. And if you want to take some time out for a holiday or a sabbatical or whatever it is you want, subject to existing professional commitments, it's within your power and your power alone to achieve that. And I really enjoy that. It's a nice part of being a barrister. Why do I like my area of practice, which is sort of construction, energy and IT disputes? I like them because they're technical. I have an IT background, but I'm not particularly technical. I did law at university, and we're often asked in our chambers, do you need to have engineering or construction background to come to us? And I always say no, and most of our members don't have that, because it would be no use. The reality is the sort of disputes that we do are so technical that no degree in the world would prepare you for them. Just a couple of weeks ago, I was doing a case about marine fouling, a specific type of marine fouling in the Arabian Gulf, for which there are only 2 experts in the world, and there could have been no degree that would have prepared you for that. But what you do is you get the experts in the field to advise you. You learn about that area of expertise, and you then present it and cross-examine the other side's expert on that. I also like it because you get to meet a variety of people. The construction industry in particular has all sorts of people from your average Joe builder right up to a project manager managing an enormous construction dispute. There are all sorts of people from all sorts of backgrounds, and you get to meet experts and clients from all walks of life, which I enjoy, and I enjoy meeting new people. There's an international element often to commercial law, which is the nature of the beast. I mean, this year I've done cases in Algeria, Dubai, Singapore, and London about projects in Trinidad, Abu Dhabi, the Gulf of Papua, just off Australia, and elsewhere. And that can be nice because you're being involved in other jurisdictions. You're understanding how their laws and regulations work, and that helps you to understand what might be improved at home. In terms of why my area of law, I quite like a little bit of specialism. And in my case, as I mentioned, it's construction, because it allows you to develop slightly more of an expertise slightly sooner. That was what attracted me in the first place. And once you've established your sort of general knowledge of the area, you can focus on being a great lawyer and a great advocate. And I suspect most commercial lawyers really want to just be the best they can be, and sort of allowing you to nail your specialism and your area of basic expertise allows you to specialise in being the best advocate you can be. As Adam mentioned, the other advantage of commercial law is it tends to be better funded. It tends to be larger commercial disputes with clients willing to pay you enough money to get to the root of the problem. You're often not doing cases the same day you receive the papers or the day after you receive the papers. You're doing cases with a fairly long lead-in that allows you to consult with the experts to really think about the problem and to do the best job you possibly can. And I quite enjoy that. And it may be, as Adam mentioned, some of the perfectionist element that one has, but it allows me to sort of scratch that itch without taking it too far. Also, as Adam mentioned, there is to some degree a convergence now between solicitors and the bar, particularly in the arbitration field. I have twice this year co-counselled with partners from law firms who want themselves a bit of advocacy experience, and we can offer them tips, and we can feed off them, and we can take advantage of their enormous resources that comes with being a big law firm. So we're seeing increasing amounts of that. So being a barrister, and particularly a commercial barrister, allows you to have that experience, but maintain to some degree your independence. So what type of cases do I do? As a junior practitioner, you will be doing a lot of things in your own right, which tend to be in the smaller end of value, and simply as you get more senior, very, very simply put, the cases get more valuable and you get paid a bit more. That's the theory. Often when you're a junior barrister, you'll also be led by a more senior barrister, and that allows you to have experience of larger disputes fairly early on in your practice. This year I've done, as I think I mentioned, a pipeline in Algeria, an oil rig in Australia, and I've just finished a case about a nuclear power plant in the Middle East. What's a typical day, and what are the lifestyle implications? I would echo much of what Adam said. This is a high pressure job, which requires you to commit yourself, and in some cases cancelling personal commitments and making sacrifices to be available for the client, and working to court or arbitral deadlines when they're given, even if those deadlines might not be compatible with your personal life. What's a typical day? Most of my time, honestly, is spent in chambers, reading documents and writing documents. A lot of our advocacy is oral, and a lot is written too. I spend time on business development, meeting clients. We have pitches called beauty parades, where you go along and you explain to clients your experience and why they should hire you with their high value case. And often we'll pitch as a team with the help of our chambers marketing function and our leaders and others within chambers with expertise. So I spend time doing that as well. We also do business development through writing papers, giving seminars, travelling to meet clients, and things like that. Finally, I just wanted to touch on the key qualities that one might need to be an effective commercial lawyer. I mentioned to some degree being a self-starter, that is, to get up in the morning, get into work early, get what you need to get done by the end of the day, knowing that the deadline for that bit of work is 20 days' time, and knowing that you have 20 days to do 20 days' worth of work. It can psychologically be quite difficult to start that on day 3 and day 4 and day 5 and not to leave it to the end. So one needs to have a fairly strong work ethic and ability to get up in the morning and do something, knowing that the deadline might be a long time away. One needs to be patient. We read a lot of documents, generally in the commercial sphere and particularly in my sphere. Contracts can be very long, documents can be very dull, and staying on top of that and focusing in on the detail, but also having the patience to read a large 80-volume trial bundle with a week to do it can be quite challenging. One needs to be detailed orientated, so you can spot where things have gone wrong, what's important in this case, and you need to be sufficiently detailed orientated not to make mistakes in your opinions and submissions. And really, as Adam has mentioned, one needs to be very emotionally robust. You are subject to constant criticism, and that can be demoralising unless you have the personal skills to overcome it. You will be criticised in your pleadings, you'll be criticised by your opponents, you'll be criticised very often by judges and much more senior barristers. And one needs the ability to pick oneself up, learn from your mistakes, be better next time, and then still fail, and then still be better next time. And that takes some degree of grit. Finally, I think an important personal quality is just interpersonal skills, being a nice person. We do have applicants, and I meet people coming to the law fairs who might have some of the best academic grades you can imagine, but they're not very able to talk to someone or relate to someone. And that's an essential part of being a commercial barrister. You have to meet clients and persuade them that you're the person that should take their case. You need to be getting on with members of chambers, some of which you'll be working with for potentially 30 or 40 years. And when you're sitting in an interview room for a pupillage, trying to convince someone to take you on, you have to convince someone that they might be in the office next to you for the next 10, 20, 30 years, and they need to get on with you. And so if those interpersonal skills are an important part of being a commercial barrister. I've probably used my time, so I'll hand over to Oliver.
Thank you. I was going to deal with why I wanted to go to the bar in my practice area together, because you'll have heard Adam mention more hardcore commercial work, which I think usually describes things like arbitration and the more pure commercial aspects of the practice area. I'm perhaps more towards the other end of the spectrum on what I would describe as commercial chancery practice. So that involves areas more like insolvency, company law, and areas like that, which tend to take place in the Chancery Division as opposed to the Queen's Bench Division or the Commercial Court. And because of that, I think my experience, both doing pupillage and in junior practice, might, not definitely, but might be somewhat different. So, for example, the reason I wanted to go to the bar generally, as you've already heard from both Adam and Peter, is the independence, absolutely. So, for example, this year I took 7 weeks off to go to Tokyo in the summer. I'm going back again for another 4 weeks in December. And I think in lots of other areas it'd be quite difficult to do that. And indeed any other career it would probably be quite difficult to do that, especially at what is quite an early stage, because I'm about to go into my 4th year of practice. So that's one of the reasons why I was attracted to the bar, and in particular the commercial chancery bar. I think, and again, I don't say this by way of, this is purely my own experience, and I don't say it in any means by way of criticism of any other area. One of the things that attracted me to the more chancery side of commercial work was the possibility that there might be a bit more court work earlier on than there is, for example, if you do pupillage and then junior practice at a set which is a very pure commercial set. In particular, and again, this is purely my own view, I think it might be that there's more opportunity to do things, particularly in insolvency areas, like interim applications, so urgent interim applications overnight, for example, in the Chancery Division, which I find I really enjoy doing those. In insolvency, that's an area where that sort of thing pops up quite a lot. And I really enjoy that kind of work, as well as, obviously, as Adam said, being able to have a proper amount of time to prepare for more substantive work like trials. I was always quite academic at university. I liked the more academic subjects. That's, again, why I was drawn more to the commercial chancery areas of the bar, just because those are the areas of law that I sort of naturally felt more at home with and found more engaging. And I think the other reason that I was particularly attracted to the area that I do is, as you say, just as has already been said, the sort of wide variety of different types of people that you get to meet. And again, sometimes in quite dire circumstances, so particularly on the insolvency side, something that I do quite a lot of is something called an application to restrain presentation of a winding up petition against a company. And usually that's an action where somebody's trying to force a company to repay a debt which may or may not be owed depending on the circumstances by presenting a winding up petition. If they do that, just to give some background, it's absolutely disastrous because the company's accounts are all frozen, they can't pay their staff. It means at least 2 or 3 trips to the Chancery Division in the next week. It can be very expensive. So it can be some really, really serious circumstances that the individuals are dealing with. And again, the pressure of that is very interesting and rewarding, especially when you manage to sort it out, as it were. In relation to the types of cases that barristers do in my areas, if I was going to split that up, I'll deal again with insolvency first, because that's my main area. So in terms of trial work, nearly all of the trial work that I do revolves around directors' misfeasance, fraud, in the sense of directors committing fraud. Usually what's happened is it's a company that's gone into liquidation, usually because of a tax debt. So HMRC is the one that have wound the company up. And the directors will have been behaving very badly and will have been engaging in all sorts of behaviour, which the liquidator of the company who's been appointed will be wanting to pursue them for. And it will either be a case of acting for the office holder, the liquidator, to try and recover those monies that have been misplaced, fraudulently used by the director for the creditors, or alternatively it will be a matter of trying to defend the director themselves or the other office holder who may well be in trouble because of the actions that they've undertaken. And I think that there are 2 aspects of that are quite difficult, but also equally aspects of it that are very good. So like Adam and George have already said, I apologise, Adam and Peter have already said, that there are areas of law which tend to be very well funded, so you do actually get the proper resources and attention that you need to put into the case to actually do it properly, as opposed to some other areas where it's high pressure in a different way, which is that it's sort of flung at you and you go off to a county court somewhere and have to scrabble about to try and put papers together. There isn't any of that. But what I find in my area in particular in insolvency is that sometimes when you're representing certain types of individuals, there really is nothing you can do for them, or there's only a limited extent to which you can assist them. And coming into the bar, that's actually quite difficult to overcome to start off with, because you're used to, especially when you do pupillage and bar course, you're used to thinking about things critically and trying to find a solution. It's all very problem-solving oriented. But in some cases, when you're, for example, in a trial that I've got coming up recently, coming up soon, in the Chancery Division, and for a number of days I'll be defending a director against some allegations that are going to be pretty difficult to defend or explain. And that can, when you start off, be quite miserable, especially because usually there'll be somebody who's very good, very senior usually, if they're on the good side, as it were, if they're on the side that's likely to win. And it can be quite demoralising because you're in a position where you're having to sort of defend the indefensible, and obviously everybody knows that you're only doing your job, but equally it's not as rewarding, for example, as when you get to act on the other side. So when you get to act for the liquidator, when you know that you're basically going to be successful. So certainly I would absolutely endorse, especially what Adam said about being emotionally robust, because certainly in insolvency I find that's absolutely vital, because very often you're in the rubbish position where you're just going to have to go to court and do your best and possibly look a bit stupid. So that's on the insolvency side. In relation to what I said about the company law, also I deal with partnership disputes. So those cases, if they go to trial, they're less likely to go to trial because they usually settle. Those cases involve things like partnership disputes, so a partner leaving the partnership, such as solicitors, is one that we're dealing with at the moment. I'm also, because I think possibly quite a bit more junior than that was really badly phrased, sorry, not quite a bit more junior, but a few more years junior than Adam and Peter. I am led quite a lot in the more core commercial areas. So, for example, I'm being led in a commercial court at the moment by Jonathan Marks, Queen's Counsel, on a dispute about helicopters, which has many very fascinating elements and jurisdictional elements. And I also deal with non-contentious company law matters, which again involves, for example, going to court to obtain approval or permission for certain types of actions that the company or directors may wish to take. And again, in terms of key qualities, I would say that emotional robustness is definitely one of them. I do absolutely endorse what both Peter and Adam have said in relation to being personable. I think that's both in relation to your clients, of course, but also with opponents and other parties in court, because particularly at the junior end, you can sometimes find that junior barristers come to court and they can be quite rude and aggressive. And I think what they're trying to do is appear robust, and some solicitors might like that, but in general, it isn't something that tends to work out very well, and also it doesn't necessarily give the best impression to a lot of your solicitors who might be there with you. So it is important to be polite and respectable to everybody, including your clients. And of course, it goes without saying that academic ability and ability to work very hard, to work long hours, is definitely a prerequisite. So yes, I think that's probably everything that I have to say. After saying that you were so much older than I was, which I didn't mean. I
Probably not wrong.
I'm sure it's also not true.
We've got time for a couple of questions.
Hi, yeah. On applications, there's always a commercial awareness question. If you were doing a pupillage application to a commercial set, what would you be looking for with an answer to that?
Law wasn't a first career for me, and I know it will be for many others. I did a couple of years of running my own business and then managing a branch of a department within a branch of a particular type of shop first, but I'd done lots of stuff outside law first. Going back to working in pubs when I was very young, old enough just about to work in pubs for a number of years, doing other things that didn't require an age qualification. You get an impression of the world, right, through broader experience. And I think there is no one answer to your question. Let's just preface what I'm about to say with that. But I think really it's important to all chambers, as far as I can tell, that the people they recruit are not just law students who've got high grades. They're people who understand a little bit about how the world works and how people work, what makes them tick. And I suspect that question is an opportunity to evidence that you are not just someone who's focused on law through all your life, and to show a bit more of your broader experience and the fact that you've reflected on the core topic matter on which you are likely to practice, which is commerce.
I'd echo that, and it's there are sometimes no real commercial aspects to a dispute. There may just be a client who wants to win and wants the best they can get. sometimes there are other factors, and the instinct of the lawyer is to jump in and continue to do the best and get the best outcome. But by way of example, I do some IT law, and I had a case last year from a startup in the UK that was doing really well, and they were expanding very quickly, and they needed IT resource, so they go to a data center and they buy a certain amount of data storage and processing capacity, and they needed to add it, and they kept adding to it every week. And they were effectively on the wrong tariff to do that. For the scale at which they were rising, they were on the wrong sort of tariff, and they ended up paying through the nose and signing into all these long-term contracts because they were more interested in getting the thing working than what they were going to pay for it down the road. And they didn't pay their bills, and the data centre came knocking. And I was asked to advise, and I looked at the case and I said, well, look, there's an arguable case here, but the reality is you've got a much greater chance of losing than you do of winning. So as a lawyer, the advice is to settle on the best terms you can and don't take this all the way, and to spend as little legal cost as you can. And the response was, well, we've looked at our accounts and we're growing at such a rate that if we settle and pay the other side's costs and pay this bill now, we'll go bust. But if we pay it in a year's time, it'll be a drop in the ocean to us. And in fact, they were right. And so the commercial awareness part of the question, I guess, came in how to do that, how to put this off for as long as possible. And the answer we eventually came to was, well, let's make the pleadings as technical and as unappealing as we can, and send it to the most inappropriate court that we can legitimately send it to, in the hope they'll transfer it to the new judge, who then transfers to the next judge, and it got kicked around the country for a few months, by which point we were ready to settle. And I think that's an example of where commercial awareness of the situation comes in. It wasn't the best outcome objectively as a lawyer, but it worked for this client. That's my experience. What's worth?
Yes. So I'm involved in pupillage recruitment in my own set in a deputy capacity only with Cheryl Jones, who runs our pupillage programme. And I think we used to have a sort of specific commercial awareness question. And again, really what we were looking for was a recognition of exactly that concept that has just been explained so well. Being able to identify when it's not necessarily appropriate to litigate for the sake of it, or in exactly the opposite situation when it would be because of the commercial reality of the situation. I suppose it's about recognising the difference between the legal reality and the commercial reality, because that comes up so often. And having an appreciation of the fact that even though disputes may be worth fighting to some extent, looking at the commercial reality of it and what the company in question is able to bear at that particular time, we're looking at a proper assessment of the risks and being able to come to a cogent piece of advice in relation to what they should do.
We've got time for one more question. Don't be shy.
In that case, I'd like to thank Adam, Peter and Oliver. I'm sure you'll probably be around in San, so if there's any further questions, please feel free to visit them. Please join me in thanking them for sharing their experience.